Assalamualaikum.
How are you?
I'm good, Alhamdulillah. How are you, Kinza?
Well, still I'm suffering from fever. Not that good.
So you did not appear for your test yesterday, right?
Yes. Yeah.
Okay, no problem. When you feel better, then you can give your test. Okay, just let
Yeah.
me know.
Sure, ma'am. I'll do.
Okay, so any questions, any queries till now?
No, ma'am.
No. Okay, so yesterday we did employment law chapter
Chapter 8.
chapter 8, and today we are going to start with the continuation of the employment law chapter 9. What is it? It's dismissal and redundancy. What do you understand by this term, dismissal and redundancy?
Dismissal, just to dismiss the person, just to take that person out of the job. And redundancy. And
Okay, when you use the word dismissal, you say that you are firing someone, okay, or you're saying someone, asking someone to leave, okay, so that is dismissal. What about redundancy? Redundancy is also when you ask your employees to leave, but in a specific situation. And what is that situation?
which can be justified.
Uh, Dismissal can also be justified, don't you think so?
But maybe if there's like a sudden scenario which they were not expecting, and they just had to redund that person, do the redundancy.
Okay, redundancy specifically means that your business is shutting down a particular branch
Oh,
or shutting down a particular department. So in that scenario, you're making the employees redundant. In that scenario, it's the need of the hour. For example, it was COVID and many organizations had to lock down. So when they are locking down, they paid their employees for a good 3 months, but then they stopped. They said, no, we are not earning anything, how can we continue to pay you guys, so we need to dismiss you, we need to make you redundant
actually,
because
they are
our
not just,
business is not running.
yeah,
If our
they are not
business is
replacing
running,
the job. Actually,
exactly,
they're just closing that job.
exactly, if our business is running, then we can pay you, but when our business is not running, how can we pay you?
And sometimes it happens like first they used to have a lot of accountants, but now just because of the computer, they don't need a lot of accountants. So I think that is also, if they're just closing up the job and they're not hiring other people, so it's, I think,
Because of technological advancement, yes, you may say so. So dismissal, if we talk about dismissal, it's a broader term, it's more general, and redundancy is more specific, that you are dismissing someone or you're dismissing the entire team, the entire department, the entire branch because of shutting down the business. That is the primary reason. Now, shutting down of the business could be due to many reasons like COVID, or maybe they are not generating profit, or maybe they just met with an accident, that particular branch caught fire, so on and so forth. Okay. All right. Let's move ahead. Termination by notice. What does this mean? Kinza, please read.
When an employment contract is terminated by notice, there is no breach of contract unless the content of the notice, such as notice period, are themselves in breach.
Okay. So what are
Actually,
they
when
saying?
we are just telling the employee that we'll be terminating you after 2 months, we are giving notice prior. Like just we give the notice to the, like landlord is giving notice to the tenant or tenant is giving. So they are just telling in prior that after this much time, you won't be able to be in this company.
Right. Next, a contract of employment.
Terminated by notice, the following rules apply. The period of notice given must not be less than the statutory minimum where the contract may specify. It should be like minimum, for example, if you talk about the tenancy agreements, it should be like 2 months. You cannot just say just yes tomorrow or maybe in a week, just leave the house and go away. You have to be specific. There should be a minimum time to be followed. It may be given without specific reason for so doing unless the contract requires otherwise. It's not necessary to always tell the reason. If the contract is saying that you have to tell the reason, so that is something else, but it's not always necessary. If the contract states that notice may only be given in specific circumstances, then generally it may not be given for any other reason. Okay, if the contract is saying that okay, you can only take that person out if that person is unfaithful or maybe any other. So you cannot take out that person of being late. So you have to follow that specific contract or rule circumstances. You have to
Okay.
see.
That's nice. The first reason is the first term or the first rule is to give a proper notice. Now, the notice is how prior you should inform that the state gives the guidance on it. If it's UK, UK will give guidance. If it's some other country, that particular country will give guidance that, okay, you should be announcing before 2 weeks before at least, or 1 month before at least, whatever. Next, it may be given without specific reason for so doing unless, excuse me, unless the contract requires otherwise. So what are they saying? That it is not compulsory to tell the reason to the employee whom you are dismissing. It is not a rule that you have
Okay.
to tell the reason. You can simply say, sorry, we cannot continue with you. That's it.
Mhm.
Unless the contract requires, unless you have agreed before hiring that person that whenever I will dismiss him, I will be telling him the reason. Okay. So unless it is stated in the contract, you can dismiss and you are not punishable, or you shouldn't be penalized if you do this without any reason. Next, if the contract states that notice may only be given in specific circumstances, then generally it may not be given for any other reason. So contract may state that in case you are laying off because of redundancy, because of closing down of the department or something like that, then you should inform beforehand. Then you should give that reason at least. Or if you're doing it because of some calamity, then you should be giving the reason. Otherwise, other than these two factors, it's okay if you don't specify, if you don't give the reason. So, state imposes a minimum period of notice of termination, and termination by notice or non-renewal qualifies as dismissal. Point to be noted. Termination by notice, that means I have given a notice that sorry, you will not be able to continue with us, or the contract has not been renewed, because a contract is always for 1 year. So after
Yeah.
1 year, if the contract is not renewed, it automatically means that you have been dismissed.
Okay.
Next. Okay. So what is the minimum period? The minimum period for an employee who has been continuously employed for 1 month or more, but less than 2 years, is entitled to not less than 1 week's notice. अगर वो employee 1 महीने से ज्यादा काम कर चुका है लेकिन 2 साल से कम हुए हैं, तो उस एम्प्लॉय को 1 हफ्ते का नोटिस दिया जा सकता है, 1 हफ्ते से कम नहीं.
Okay.
That is what UK law tells us. Okay, so when UK law is telling us something, it is of international standard. Okay, it is something which is acceptable to most of the people internationally. Not all, but most of the people. Then, an employee who has been continuously employed for 2 years or more, but less than 12 years, is entitled to 1 week's notice for each year of continuous employment. यानी हर साल के लिए एक हफ्ते का नोटिस, अगर उसने 2 साल या ज्यादा काम किया हुआ है. So for example, the employee has been working since 3 years, so we should give him at least 3 weeks notice. Okay, but it's less than 12 years. Okay, the time period is between 2 and 12.
Okay.
Next, an employee who has been employed for 12 years is more is entitled to not less than 12 weeks. And 12 weeks
Okay.
means how many months?
3 months.
3 months. All right. So I hope these facts are noted and they are just clear. Moving ahead. If employee is dismissed in any way, they may request their employer give them a written statement of the reasons for their dismissal. अगर एम्प्लॉय को निकाला जा रहा है तो एम्प्लॉय रिक्वेस्ट कर सकता है कि भाई मुझे इन राइटिंग बता दें कि मुझे क्यों निकाला जा रहा है, द रीजंस, एंड द एम्प्लॉयर मस्ट प्रोवाइडेड विद इन 14 days. 14 दिन के अंदर अंदर एम्प्लॉयर को प्रोवाइड करना पड़ेगा. Dismissal is the word used to describe termination of an employment contract by the employer. डिसमिसल क्या है कि एम्प्लॉयर उसे अलाफिस कह रहा है, टर्मिनेट कर रहा है कॉन्ट्रैक्ट को, दैट इज डिसमिसल. Okay, and there are 3 types of dismissal, as you can see over here. The first one is the summary dismissal, the second one is the constructive dismissal, the wrongful dismissal, or the unfair dismissal. Okay, now these two are similar words, but we'll see what each of them means. So first, summary dismissal, please read.
Summary dismissal is where the employer dismisses the employee without notice. They may do this if the employee has committed a serious breach of contract. Like if he is stealing up, so obviously they will not wait for another 1 week. They cannot take any risk now because he has done some serious issue. So now it's going to be a summary dismissal. They will not be providing any notice. They will just straight away dismiss the person.
Summary dismissal बहुत short notice पे और abruptly. Okay, and definitely there's a serious breach of contract. That means the employee has either committed a kind of a crime or was involved in any illegal activity or was harassing someone. Some people call it harass, some people call it harass. Okay, so you're harassing someone, so you're caught there, and so that's called summary dismissal. Constructive dismissal, read.
Constructive dismissal is where the employer commits a breach of contract, thereby using the employee to resign. By implication, this is also dismissal without notice. Like if the employer is forcing the other person, the employee, to just sign up the resignation and go.
No, constructive means the employer commits a breach of contract. There was a contract between employer and employee, and in this case, the employer has breached the contract and he has not fulfilled the terms and conditions he agreed earlier. For example, he might have said that I'll give you a bonus, or maybe I'll increment your salary once 6 months are done. And after 6 months, there is no increment, no bonus, nothing. So the employee might do this. He might sign a resignation letter and he give it to the employer that sorry,
Or he
because
got
you
another
dismissed.
job. Yeah.
So that's constructive dismissal. No, this is not resigning because he got another job. Point to be noted. The question may come and you might get confused over here. They are resigning because employer did something wrong.
Okay.
Okay, it could be anything. It could be a breach of contract, it could be maybe harassing, it could be anything which employer has done, and because of that action from employer, the employee decides to resign.
Okay.
Wrongful dismissal
Is a common law concept arising in specific circumstances. It gives the employee an action of breach of contract.
Right. So in wrongful dismissal, what is happening? A common law concept arising in specific circumstances. It gives the employee an action for breach of contract. Okay. Unfair dismissal. Let's first read both of them, then we will understand.
Unfair dismissal is a statutory concept introduced by employment protection legislation. As a general rule, employees have the right not to be unfairly dismissed.
Read the last line as well.
Corresponding fair dismissal is a statutory concept where a person has been dismissed as a result of a fair reason under legislation.
Okay. Exam focus point.
Note that the distinction between wrongful and unfair dismissal depends not so much upon the nature of the dismissal as on the remedies available.
Right. So both are basically treated or given remedies differently. For wrongful dismissal is different and for unfair dismissal is different. That's what makes them different. Wrongful dismissal, okay, just keep marking for yourself. Wrongful dismissal is a common law concept. Unfair dismissal is a statutory concept. Okay, and unfair dismissal is launched or given by the employment protection legislation. It's a law created or made by the state to protect employees and employers. Now employees have the right not to be unfairly dismissed. What do you understand by this unfair dismissal? What do you think would be the reasons of dismissing someone unfairly?
If like my employer is being biased, he has some personal issues with me, or he is just doing
Exactly.
favoritism, so it's unfair.
Exactly. Anything else? Dismissing you on the grounds of your maybe pregnancy.
Yeah,
Dismissing you
discrimination.
on the grounds of maybe you're a Muslim or you do
Yeah,
hijab. So
maybe
that
color.
may be color. So that all falls under unfair dismissal. Okay. Wrongful dismissal, it happens or it arises in specific circumstances. Okay. It gives the employee an action for breach of contract. So there has been some breach of contract somewhere. Okay. Now the contract, either the terms and conditions are not fulfilled, or it may happen that either the employee is caught in the illegal activity or is being blamed to be responsible for some illegal act, but in reality, he is not responsible. Like, for example, there's an employer, and for just imagine the scene that you're doing job in a company, okay, and there are many offices inside the company, many rooms, okay, everybody is working, and you are also working as an accountant, and you happen to go to your manager or supervisor's office, okay, and as you enter the office, somebody pushes you and runs away, and
Mhm.
you are confused that why this person pushed me and ran away, like,
Yeah,
he can come by walking, like why is he running, why
exactly.
is he in so much of rush? Then you ignored him and you go inside the office, and as soon as you enter the office, you see that your supervisor is lying down, knife on his chest, and all blood all over. What will
Hmm.
you do? What will be your first reaction? You will scream, you will shout, you maybe you
Yeah,
will run,
call the security.
all the security, maybe you will run to help the supervisor. And in order to help him, what will be your first action be? You might be trying to take out the knife. And
Yeah,
as you're taking out the knife, somebody else comes in and they see you. And they get this perception that, oh my God, you are murdering the supervisor.
yeah,
Okay. And now this perception puts you in a lot of trouble, and everybody starts thinking that you're the one, you have been caught red-handed, okay, you are the one who is responsible for the murder, and definitely then you will be charged against this crime, yes or no, and you will get stuck,
yes,
and you will get stuck, and the first action by the employer would be to dismiss you, and you have been wrongfully dismissed. In the court, when you will go to the court, then the matter will be investigated and everything will come over there and the facts and the figures, and then there you can say that I have been wrongfully dismissed. I am not responsible for the crime. Somebody else
Okay.
was there before me. I just went there to give a file, to submit a file. I had no clue that this would be happening out there. So then
Okay.
you would be putting up in front of the court your case. That's wrongful dismissal. Now, can you see that how the breach of contract is coming into place?
Yeah.
I just gave you an example of a very serious scene and a very serious crime. But
Yeah.
what employees do, they are more often employed in small crimes, like just picking up some petty cash,
That's right.
hiding, manipulating some accounts, or maybe just helping someone in money laundering. So these kind of things, if you're caught, then you will be dismissed and you might be blamed wrongly for that. So that is called wrongful dismissal. All right, termination of employment by breach of contract. What do you understand by this? That when you breach the contract, you will be terminated. Now, how
Mhm.
could you breach the contract in order to be qualified for termination? Please read.
Breach of the employment contract occurs when there is a summary dismissal, constructive dismissal, inability on the employer's side to continue employment, or reputation of the contract by the employee. An employment contract is
Okay,
terminated
wait. Let's just recall. What is summary dismissal?
when they are giving the when they're just terminating the dismissal, doing the dismissal on a very quick notice.
Very quick notice, maybe
Yeah.
abruptly. Okay,
Yeah.
कस्टमर से बदतमीजी कर ली, बस निकलो यहाँ से.
Hmm.
We can't keep you on our team. Next, constructive dismissal.
When they have like giving the notice and just doing the dismissal.
Constructive dismissals, something has happened, as we discussed earlier. The employer has done something wrong. He has breached
Hmm.
the contract. Maybe he has promised for increment or bonus, and he did not do it actually. And because of that, the employee resigns.
Mhm.
That is constructive dismissal. Okay. Then inability on the employer side to continue employment. Now that could be that the business is not running, the employer is bankrupt, so there is no money to pay, so he will not continue the employment. Or repudiation of the contract by the employee. What does that mean?
Representation. Now employee is not interested in the job. Reputation of the.
Maybe he's backing off the contract, right?
Yeah.
Repudiation. Okay, it will become clear as we get through the text.
Okay.
All right. So you can go through this. These are the detailed paragraphs for a better understanding. A repudiation by the employee. Yes, please read.
Repudiation of the contract by the employee, resignation, striking, or failing the performance of the contract, and to observe its conditions is breach of contract by the employee. The employer may dismiss them or treat the contract as discharged by the employee's breach.
क्या कह रहे हैं?
Resignation, the breach of contract by the employee. Now the employee is just breaching of the contract and he is not interested anymore. Without any reason, I get the employer.
All right. The thing is that, for example, I hire Mr. X. Okay. I hire Mr. X. I tell Mr. X that join from tomorrow. Your timings would be 9 to 5. I tell him the job. We both sign the contract, and we are good to go. And he must start coming from tomorrow. Tomorrow comes, he does not come. Okay. I wonder that why has he not come? Second day comes, he does not come. I wonder again what's wrong. Then I make him a call. I ask him that what happened, you're not coming. said, oh yeah, I'm not well. I'll come. I'm not well. Like he's just making vague excuses, and I'm not satisfied when he says I'm not well because he's not giving the details. The third day comes, he does not come. The fourth day comes, he does not come. The fifth day comes, he does not come. What am I supposed to do?
He's actually just giving the lame excuses. He's not interested.
Yeah, so what will I do? I'll then treat the contract as discharged because the employee
Yeah,
is not
of course.
performing his side of the duty, his side
Yeah.
of the contract. Okay, next, employment tribunals. What are employment tribunals? Read.
Employment tribunals has jurisdiction to deal with all matters of employment related disputes, such as wrongful and unfair dismissal and redundancy, which formerly had to be here in the civil courts. The employment tribunals constitution and rules for procedures regulations 2013 applied to them.
Right?
Okay, they have made specific bodies for the tribunals. These are called tribunals, and they look into the employment cases.
Exactly. Why? Because there are so many companies and so many issues.
Exactly.
Earlier, civil courts used to hear them, but later they realized that no, it's not possible to hear so many just company related cases in civil courts because civil courts is for civil cases. It could be family case, it
Exactly.
could be divorce case, it could be child custody case, but the employee case, employer cases are also coming in huge numbers. So let's make a separate body to just hear their cases, employee and employers cases, right? So they specifically made this body known as employment tribunals. Okay, moving ahead, settlement agreements and earlier conciliation. Again, it's better not to proceed with a further court or more legal, get into the more legal side of it because it takes more time. And Kinza, what else?
It makes more money,
More
time,
money and
yeah, resources. Just
resources, and
yeah,
the reputation of the company is also at stake
exactly.
because the
Yes,
media comes into the media
exactly.
becomes involved. So it's better to baro bari मामला सुलझाई जब.
True.
अच्छा जी. Wrongful dismissal. Yes, please read.
Where the employer has summarily dismissed an employee without notice, as where the employer becomes insolvent. There may be a claim of damages at common law of wrongful dismissal. If like you have dismissed somebody wrongfully, then you have to pay the damages because obviously that person must have been gone through depression, anxiety, and you dismissed that person straight away. It's summarily dismissed because you didn't even give him a chance to speak up. So if it's you have proven wrong, then you have to pay the damages.
Exactly, and there was no notice period as well.
Yeah.
Now, what could be the justification of dismissal? Because no company wants to pay the damages, right? So what
Yeah.
can it say to justify the way they dismissed a person? Please read.
And willful disobedience of a lawful order if it amounts to willful and serious defiance of authority.
They
Okay,
can
they are
say
now
that the
saying
employee is not obeying our orders.
following the law. Yeah.
Exactly. So that's why we had to dismiss him. Second reason.
Misconduct in connection with the business or outside it, if it is sufficiently grave. For example, acceptance of a secret commission, disclosure of a confidential information, assault on a fellow employee, or fraud by an employee in a position of trust. Okay,
Exactly.
they have to prove that he did not kept the secrets or anything related to that.
Yeah. Next.
Dishonesty where the employee is in a position of particular trust. Yeah.
Next.
Incompetence or neglect insofar as the employee lacks or fail to use skills where they profess to have.
Okay. So अब देखो हो क्या रहा है? What is happening? There are two parties, party A and party B. Party A is the employer, party B is the employee. The employee files the case in the court and says, I am wrongfully dismissed.
Yeah.
Then, of course, the employer A will be called in the court. Employer A, what will he say? He will say, no, I did not dismiss him wrongfully. I have dismissed him rightfully. Why? These are the reasons. He disobeyed the lawful order. He misconducted himself. He was dishonest, incompetence or neglect, gross negligence, immorality, drunkenness. These were the reasons I had to dismiss him. So the court will listen to both sides, look at the facts and evidences, and then it will decide that okay, was it wrongful dismissal or not? If yes, damages needs to be paid. If no, they both will go dismissed. Remedies for wrongful dismissal. What are the remedies? Again, damages. Okay, so we know the damages and proper notice. Next, unfair dismissal. Please read.
Certain employees have a right not to be unfairly dismissed. Breach of that right allows an employee to claim compensation from a tribunal. To claim for unfair dismissal, the employee must satisfy certain criteria. Okay, they will be compensated not by the company but by the tribunal if they have been unfairly dismissed.
Yeah, so now what would be the damages for the people who are unfairly dismissed?
Unfairly dismissal is an extremely important element of employment protection legislation. The remedies available following a successful action for wrongful dismissal are limited to damages compensating for the sum which would have been earned if proper notice had been given. Legislation seeks to widen the scope of protection and increase the range of remedies available to an employee who has been unfairly dismissed. Under the Term of Employment Right Act 1996, a statutory maximum compensatory award is set every year, which a tribunal may award to an employee who is unfairly dismissed.
Okay,
They're
so
telling the same, they're telling about the damages, like if you have been affected, then you will have you will be paid a compensation amount by the
So what is it saying? Employment Rights Act 1996. It sets a statutory maximum for compensatory award. The compensatory award, the damages would be paid by whom? The state, right?
tribunal. Yeah,
By the
by the state.
tribunal. So they set that maximum award that इससे ज़्यादा नहीं pay करेंगे, ये limit है. इसके नीचे नीचे and it
But why
depends.
not the company? Why the tribunal?
See, the thing is, unfair dismissal has been done, okay, on the basis of bias, on the basis of something you can call it discrimination of gender, discrimination of race, discrimination of countries. Now, what is here possible? That either you ask the company to pay, okay, you ask the company to pay the damages, and if the company refuses, though it cannot because it's a court's order.
Yeah,
But if you see over here carefully, the tribunal is involved, not the court. It's the employment tribunal. And the tribunal is asking them to do it. And they are being stubborn and they are saying, no, मैं हम तो नहीं देते, हम तो हमें नहीं देना. हम और इसको दें पे मतलब हम इसको damages दें हमने इसलिए तो उसको निकाला है because we don't like it.
mhm.
Okay, so sometimes this happens. So a statutory maximum compensatory award is set every year, which a tribunal may award to an employee who is unfairly dismissed. The thing is, discrimination on the basis of religion, caste, creed, color, gender, ये सब
Age.
ऐसा है, age, ये सब देखो हम लोग कुछ चीजें ना इमेजिन नहीं कर सकते. We live in a country where our basic human rights are not given to us and it's exploited.
Exactly.
So
And we are very
what
used to it, to be
we are
honest.
very used to it. हालांकि हमें हमारा दीन सिखाता है कि लक़द कररमना बनी आदम, कि अगर if you are a human, if you are a child of Adam बनी आदम,
Mhm.
लक़द बेशक, लक़द कररमना बनी आदम, अगर आप बनी आदम की औलाद हैं तो आप इकराम के काबिल हैं. फुल स्टॉप. नो इफ्स नो बट्स. दिस रिस्पेक्ट, दिस नोबिलिटी, दिस status is given to a human by his creator, our Lord. Nobody can take it away. So when a person is discriminated or denied his rights. A person is very competent. You are very competent, Kinza, and I don't hire you because I don't like you, because you're a Pakistani. How will you feel personally? You will feel so degraded.
Demotivated, yeah.
Not demotivated, you will feel insulted, you will feel
Yeah,
degraded, that
humiliated.
having
Yeah,
a green passport is so degrading that nobody is accepting me in another company.
that's right.
राइट सो अब ये जो डीग्रेड करना होता है, किसी इंसान को डीग्रेड करना, ये बहुत बुरी बात होती है, ये इंसानियत से के लेवल से नीचे की बात होती है। ठीक है, तो आप कंपनी से डेफिनेटली कंपेंसेशन लोगे, मगर बहैसियत स्टेट, बहैसियत कंट्री, the country feels so bad about it. The country feels its personal responsibility that no human that comes to his country or is living in his country is being degraded for being a human he is or she is. अगर कोई भी कंट्री से हो, कोई भी जेंडर के हो, कोई भी रेस के हो, कोई भी रिलीजन को फॉलो करते हो, प्रेग्नेंट हो या नहीं हो, you have a respect as a human, you have a dignity as a human, and that should not be taken away from you at any cost. So because you were denied of that and you were made to go through such a humiliating incident, the state also gives you a compensatory award, that okay fine, this is for you, you know, to just, we cannot bring back your the pain you went through, that experience.
That's right.
We cannot you know, bring back the time or reverse it, but we can compensate you more. So to make you feel that we are with you, you have been wrong, we are with you, it was not right, that has been, yeah, that it, the treatment, the way you were treated is not right, the way you
But
were treated is not right, and we oppose it. We are with you, the state is with you. That is how they make them feel better. Because if you imagine, ये तो कुछ भी नहीं है, मतलब Kinza, just on a personal level, I don't know, have you ever gone through it, but I have gone through it, and I have seen so many people going through it in this society we live in, that there is such a big difference in a ladka and a ladki, beta
exactly,
and a
it's a male
beti.
dominating society. Yeah, that's right.
बेटा पैदा होता है तो खुशियां मनाते हैं, बेटी पैदा हो जाए तो कोई मुबारक का कॉल भी नहीं करता, लाइक
True.
लिटरली। एंड देन फिर दो बेटियां हो जाए तो होय होय हो जाती है,
Exactly.
कि अब क्या होगा, तो दो हो गई, अब तो दो का वो जहेज सजाना है, अब तो दो को वो करना है। ठीक है, तो वी हैव गॉन थ्रू इट at some point or the other, at minimum level or at an intense level. It's so humiliating. I didn't choose to be a female. Neither
Yeah,
did the boy choose to be a male.
that's right.
Okay. And our Lord gives this, tells us that it's a right. कि क्या होता है लड़का लड़की? लैसा ज़करा कल उनसा. What is this लड़का लड़की? दोनों को मैंने बनाया है, दोनों मेरी तख्लीक है, दोनों का अपना रुतबा और मकाम है, और मैं जिससे चाहे काम ले सकता हूँ. If I choose a girl, then he can choose Maryam to perform the job he wants. If he wants to choose a boy, then he can choose a boy Isa, right? To fulfill the responsibilities. So there is no difference between a boy and a girl in the eyes of God.
And everybody has their own responsibility and designation.
Exactly, exactly. तो जब आप ये तो हम अपनी सोसाइटी की बात कर रहे हैं. If you talk about the American society, over there they discriminate the black and the whites.
Yes, that's right.
And it's so humiliating. It's so humiliating. So we can't imagine the humiliation that particular person goes if he is denied something which he is worthy of and he deserves it, and he is not given it just because he is black, or just because he is underage, or just because he is a girl, he or she is a girl, or just because he or she is, you know, transgender or something. They are not given equal opportunities, so that is unfair. And for that, the company will be paying the damages, the company will be penalized, the company will be given some, you know, punishment. But along with that, there would be a statutory maximum compensatory award as well. Okay. Next. Scope. Scope. What is the scope? Persons employed to work outside the UK do not fall under this. Okay, they are excluded. Why? Because we are studying UK law. Okay, so employees dismissed while
Yeah.
taking unofficial strike or industrial action, then also these laws are not applicable. And then other categories, including members of the police, like if it's about dismissal of a police, or it's a dismissal about of a judge, or it's a dismissal of a very high post in any place, then the rules are slightly different, and they do not fall under the scope of the UK law which we are studying right now.
Like for example, I'm living in UK but working in Pakistan or maybe any other country. So that country's law will implement on me, not you.
Employment law, yes. Yes, because you're doing job under the employer of that country, no? Now, making a claim. Okay, you can just go through this para. I'm leaving this for your self-study. Okay, not going into the depths. Yeah, making a claim. There are 4 steps to make a claim for compensation for unfair dismissal. Now, how the employee should file the case for unfair dismissal? He should apply to a tribunal within 3 months. ऐसा नहीं हो सकता कि आपके साथ ज्यादती
एक
हुई
साल
और
बाद
1
आ
साल
रहा
बाद आप आ रहे हो.
है.
Step 2, employee must show that they are qualifying employee, that they were employee of the company. They were not self-employed, okay?
Oh,
Step 3, the employer must demonstrate what was the alleged only or the principal reason for dismissal. Because employer will not say na कि वो black था इसलिए मैंने उसको निकाला. The employee would say, no, he never used to do his work on time. He was coming late.
so he
Right?
should have a specific reason which can clearly tell what the real reason was of
Yes.
dismissal.
The employee can say late से मैं तो नहीं आता, दूसरे employees भी आते हैं तो उनको क्यों नहीं निकाला, सिर्फ मुझे ही क्यों निकाला.
True.
ठीक है, so this could be a reason. Next, that it was one of the statutory fair reasons for dismissal or otherwise a substantial reason of a kind as to be capable of justifying the dismissal of an employee in this position. Anyhow, the employer will try to defend himself, right? So he could give whatever possible reason he wants to give to save himself, to escape this burden, to pay the damages. Then the tribunal must decide if the principal reason did in fact justify the dismissal. Now it's the job of the tribunal to look at the evidences and then to decide who is right and who is wrong. So step 1, step 2, step 3, step 4. Clear?
Yes, clear.
Next. If the employer cannot show that the principal reason allegedly justifying the dismissal was one of the fair reasons given in statute, the dismissal is unfair. Dismissal may be identified in 3 circumstances. Actual dismissal, please read.
Actual dismissal can usually be clearly recognized from the words used by an employer.
Next.
Constructive dismissal, as described earlier, involves a fundamental breach of employment contract by the employer. Expiry of a fixed term contract without renewal amounts to a dismissal.
Right. Can you please explain one by one?
Actual dismissal is whatever the employer has given reason, it can be clearly seen. There is nothing confusion in it.
Right. Actual dismissal means they give in clear words, they tell the same thing that they meant. Next.
Constructive dismissal is when the employer is breaching of the contract and is not following it anymore.
Right. And lastly,
expiry of a fixed term contract, like they are not renewing without any renewal. Obviously, it's like contract is finished. So if the contract is like for 1 year or 11 months, then later on you can do whatever you want. You are not bound to let the employee know 1 week earlier or whatever it is.
Right. Now, can you please read this last sentence?
The employee must show that they have in fact been dismissed. The court often have to debate whether or not to use the abusive language by employers constitutes merely abuse or indicates dismissal.
So if the employer is shouting at the employee or maybe getting angry upon him using some abusive language, it does not mean that he has dismissed the employee. But some employee may think that they talked to me so rudely or they insulted me in front of everyone. So I think it was just a dismissal and he doesn't want me to be here to work anymore, so on and so forth. Okay, but does the court consider it or not? It depends. They can debate on it. The reason for dismissal. Okay, the reason for it again, it's the same. Reasonableness of employer. Was the employer acting reasonably? Were the procedures applied? All the circumstances were taken into consideration or not? Or was the reasonable employer have done? मतलब जो उसने उस सिनेरियो में क्या क्या कोई और एम्प्लॉयर भी वही चीज करता उसी सिनेरियो में. So these are the things which a court can consider when checking on the fact that the employer had acted reasonably or not, right? Next, the disciplinary procedure. Please read. What is the disciplinary
Employees are
procedure?
required to follow
ACCA's
ACCA's statutory code of practice on disciplinary and grievance
grievance
procedures.
procedures. Now, अब
The
अगर उसको कुछ नुकसान हुआ है, कोई मसला है, कोई शिकायत है, तो अब क्या procedure लिया जाएगा on disciplinary and grievance procedures? So, what could it be done? This provides basic practical guidance to employers, employees, and their representatives, and sets out principles for handling disciplinary and grievance situations in the workplace. देखो भाई, जिंदगी है, काम कर रहे हैं, कंपनी है, इंसान है, कॉन्फ्लिक्ट्स भी होंगे, खड्डे भी होंगे, कभी बड़े होंगे, कभी छोटे होंगे. तो जब कभी कोई ऐसा बड़ा खड्डा हो जाए किसी दो डिपार्टमेंट के दरमियान या किसी दो इंडिविजुअल्स के दरमियान, तो उसके लिए क्या प्रोसीजर फॉलो करना चाहिए? क्या सिर्फ निकालना, नौकरी से निकालना ही एक सोल्यूशन है या कोई और सॉल्यूशंस भी हैं? What should be the practice in any company? So the stage 1, the employer investigates the matter to establish the facts of the case. So stage 2, the employee is informed of the problem. Stage 3, meeting is held. Stage 4, decision is made and appropriate action is taken. Stage 5, the employee has an opportunity to appeal the decision.
Okay.
So this is what, these are the guidelines given by the government, by the law. The code tells us that, okay, you follow this. Stage 1, investigate.
Yeah.
Stage 2, inform the employee. Stage 3, meeting. Stage 4, decision. Stage 5, employee has the opportunity to appeal for the decision. That, okay, that I don't believe that this is the right decision. Okay, warnings.
Except in severe cases, it is not reasonable for an employer to dismiss an employee without first warning them. And if they continue or repeat their behavior, they are likely to be dismissed.
So warnings is also there. Next, concluding on
Except for the very severe case. If it's very important, then obviously no warning would be conducted.
So now concluding on reasonableness, we know that reason, how we can decide that is it reasonable or not. Okay, it's just a repetition. Next, unfair dismissal, justification of dismissal. Of course, people will try, employers will try to, hide their real reasons, and they would say that no, they were not capable, they were not qualified, their conduct was not good, the redundancy, we had to shut down because of COVID, we don't have so much of profits, or they can even say legal prohibition. The government is not, the government has imposed some kind of a rule, some other substantial reason. कोई और भी रीजन हो सकता है जो अभी हमें ज़हन में नहीं आ रहा. Okay, they can defend their decision in some way or the other. All right, moving ahead, just the explanation of the details, nothing much. Automatically fair reasons for dismissal. What could be the fair reasons which are fair, like which is but obvious, nobody would object? Number 1, अनऑफिशियल इंडस्ट्रियल एक्शन. कोई ऐसा आपने काम कर दिया है जो इंडस्ट्री नॉर्म्स के अगेंस्ट है और बहुत सिवियर है, या उसका आफ्टर इफेक्ट बहुत बहुत बुरा हुआ. करोड़ों का नुकसान हो गया या कोई किसी की जान खतरे में आ गई. नेक्स्ट, थ्रेट टू नेशनल सिक्योरिटी, कोई टेररिस्ट एक्टिविटी में पकड़ा गया. So these could be the two fair reasons for dismissal. Nobody would object it. Automatically unfair reasons for dismissal. Quickly go through it, Kinza.
Pregnancy or other maternity related grounds, a spent convocation under the Rehabilitation of Offenders Act, trade union membership or activities, dismissal on uh, if you're a member of union and activities, then they cannot dismiss you.
Yeah, these are the unfair reasons.
Yeah, okay. Dismissal on transfer of an undertaking unless there are economic, technical, or organizational reasons justifying the dismissal. Taking steps to avoid danger to health and safety at work, seeking to enforce right relating to the national minimum wage, exercising rights under the working time regulations, refusing or opting out of Sunday working in the retail sector, making a protected disclosure and order under the public interest disclosure.
Okay. Any point that you did not understand?
Like if you are a teacher and they're asking you to come on Sunday, then you can say that no, I'm not going to come on Sunday.
Right. So proving what was the reason for dismissal. All right. You have to prove whatever the reason is, you have to prove that yes, that was the reason. There is no other hidden reason behind it. Next, remedies for unfair dismissal. What could be the remedies? Number one, reinstatement, re-engagement, compensation. Reinstatement, you will be given your job back. Re-engagement, you will be given your job back, but not in the same department or under the same boss. Maybe somewhere, some other department in that same
But
company.
the same organization.
Same organization, it is also possible that you will be engaged in the another organization. Means it will be the responsibility of that particular company to engage you somewhere.
Okay.
And the third, compensation, that is, we have discussed it.
Yeah, the damage.
Okay. Redundancy. We know that the employer is dismissed by reason of redundancy, laid off, or kept short on time. If these are the reasons, then they are liable for redundancy payment. Okay.
Yes.
And it happens when the employer has ceased to carry on the business.
Yeah, for maybe I think 2 months or so they have to pay.
Maybe for one
If they have
department,
to
maybe for one branch, maybe for, the entire thing is shutting down. That is redundancy. Okay. So I would just recommend you to definitely go through the text part. Exceptions to the right of redundancy payment. Like for example, an employer might say that no, sorry, I cannot give you redundancy payment. So when he is allowed not to give, when the law will accept the fact that okay, these are the exceptions, if he cannot give, then it's okay. So how? They do not fit the definition of employee if that particular person is not employee. If he is self-employed, then he is not liable for redundancy payment. Secondly, if they have not been continuously employed for 2 years,
okay, less than
then
2
also
years.
they
So
are not liable for redundancy payment. If
yeah.
they have been or could be dismissed for misconduct, कि वो तो पहले से ही बदतमीज थे, उनको तो निकालना ही था, तो हम
So
इनको
it's a
क्यों
dismissal, right?
हाँ, हमें उनको
Not a
निकालना ही था.
redundant.
अब वो इत्तेफाक से हमारा डिपार्टमेंट भी बंद हो गया, मगर हमें उनको निकालना ही था, तो हम उनको रिडंडेंसी पेमेंट क्यों दें भाई?
Okay.
ठीक है. नेक्स्ट, एन ऑफर टू रिन्यू द कॉन्ट्रैक्ट इज अनरीजनेबली रिफ्यूज्ड. हम उनके साथ कॉन्ट्रैक्ट कंटिन्यू ही नहीं करना चाह रहे, उनका कॉन्ट्रैक्ट भी एंड की तरफ था, साल खत्म हो गया, कॉन्ट्रैक्ट एंड था, हमने तो रिन्यू भी नहीं करना था, तो हम क्यों दें रिडंडेंसी पेमेंट? सो दीज आर द प्लेसेस वेयर कंपनी इज ट्राइंग टू सेव द पेमेंट that it should have, that it would otherwise pay, but the law has also given the permission that okay, in these cases if you don't pay, it's okay. Claim is made out of time after 6 months. redundancy payment की announcement आज हुई है, साल बाद कोई बंदा उठ के आ रहा है और बोल रहा है हाँ हाँ वो तो आपने अनाउंस किया था, मैंने तो अपना पेमेंट लिया ही नहीं आपसे, मैं तो लेने ही नहीं आया. ऐसा नहीं हो सकता. आप 6 महीने के अंदर अंदर आओगे, आपको दे दिया जाएगा, 6 महीने बाद आओगे, कुछ नहीं मिलेगा. Employee leaves before being made redundant. उसने तो खुद रेजिग्नेशन दे दी, या वो रेजिग्नेशन उसकी तैयार थी, उसने बताया नहीं था ऑफिशियली, हमें पता चल गया और फिर 2 दिन बाद रिडंडेंसी अनाउंस हो गई। तो हम उसको यही बोलेंगे कि आप तो पहले से ही जाना चाह रहे थे, रिजाइन रेजिग्नेशन लेटर तो आपको रेडी था फिर। ठीक, नेक्स्ट, layoff and short time. Layoff and short time means that you're firing your employees for a short period of time or laying them off because, you know, of course, are some critical financial situations you are going through. Strike action, employees involved in strike action after redundancy notice is served will be entitled to a redundancy payment. However, if they are on strike when the notice is served, they will not be eligible for payment. Is this clear? That if the employee is on strike and the redundancy bill has been announced, they would not be.
So they will not be
entitled.
eligible.
Yes. Okay, so here we have completed this chapter. Any questions till now? Any queries?
No, ma'am. Clear.
Okay. So let's just quickly see that how many chapters we are done with. So we have completed both of these chapters, Alhamdulillah, contract of employment, dismissal and redundancy. We are done with part A, part C, and part G and H. Now we are left with only part F, E, and D, 3 parts, okay, which constitutes of how many chapters? 5, 6, 7, 8, 9, 10, 11. We still are left with 11 chapters, okay, and we'll be going through it. Okay, if I just talk about part F. Part F is more of a revision from F1. It's about company directors, company officers, company meetings, hierarchy, resolutions. So it's more of a F1 brought forward knowledge. So I would recommend you that first we would be going through D and E, and in between I would be giving you like, okay, if you have time today, just go through this chapter. If you have time today, just go through this chapter. So the next day, what we will do, we will go through it faster. Okay, so it does not become boring. Next. Okay. Let's start with part D because we still have 1 hour with us. Let's start with part D. Agency law. Okay, what is this agency law? Page 161. What do you understand when you hear the word agent?
Agency agent, when they are just dealing in between the claimant and the claimer, the agency is the middle person.
The middle person, agent. Okay, an agent who makes the contract happen. Now there are two parties. One is called the principal party, P, principal party, and the other is the client or the customer. So the contract is between the principal party and the client, but there is a person in between who is called an agent who connects these two parties. The agent's work is to connect the principal and the client in a contract, to connect them. He acts as a bridge. Okay, because the principal is operating somewhere else, the client is operating somewhere else, and the client is looking for something that principal is offering, and the principal is also looking for something that client is offering. So the agent is in between, he is in touch with both of them, and he connects them both, and he makes them come into a contract. And what he gets in return, what the agent gets in return? Agency fee. Okay, he takes the agency fee from the principal and the client both. Now, role of agency and agency relationships, we have discussed this just now. Now, what kind of agents, what types of agents are found? Number one, partners. Number two, company directors. Number three, promoters. Number five, factors. Number six, brokers. Number seven, auctioneers. And number eight, commercial agents. So all of these are somewhere or the other an agent. Partners, how partners are agent? Can you please explain? There are two partners in a business, A and B.
Yeah.
How they act as agent for each other or for the business.
They'll be making up the contract and talking to each other about it. And
Exactly. Like for example, दो भाई हैं, ठीक है, ए और बी. ये दोनों भाइयों का एक मुश्तरका बिजनेस है, तो ये दोनों पार्टनर्स हुए. अब ए अगर क्लाइंट से कोई बात कर रहा है और क्लाइंट के साथ कोई अंडरस्टैंडिंग या डील हो जाती है, तो ए और सी कॉन्ट्रैक्ट में आ रहे हैं, यस और नो?
yes,
मगर ए एंड सी के कॉन्ट्रैक्ट के आने के नतीजे में डू यू थिंक कि बी इज बाइज्जत बरी?
no,
बी इज ऑल्सो इन्वॉल्व. तो
yes,
इसका मतलब क्या हुआ कि कॉन्ट्रैक्ट बी और सी का भी है.
true,
तो बी और सी का कॉन्ट्रैक्ट में फिर एजेंट का रोल किसने प्ले किया? ए ने. So this is how a partner becomes an agent or plays the role of an agent.
okay,
Same goes for B. B is cracking a deal with client F. So if he gets into a contract with F, do you think A is not liable for that contract?
A is
A is. Why? Because they are joint partners. And
exactly,
therefore B has acted as a agent for A.
okay,
Now, company directors, they act as agents for the company. They act
yes,
as agents for the shareholders. Okay,
yeah,
because they are running the company on behalf of the shareholders. So
exactly.
therefore,
Whatever the company is promising, they are bound to follow. They have to make sure
exactly,
that everything's
exactly. Then a promoter. Who is a promoter?
who's promoting the product, marketing.
No. If you have studied F1, a promoter is the person who initiates the idea of building a company,
Okay,
of establishing a company.
the
He
founder.
is the founder. The founder. He is the one who starts, who goes to the registrar, who gets the company,
Okay,
you
took
know.
the initiative.
Yes. So that person is called a promoter. So at that time, he's acting as an agent for the company.
Yes,
Next, factors.
factor sometimes called this person's job is to sell or buy goods in behalf. Okay, if like the third party is buying the good on your behalf, then it's a factor. The both of the owners are not directly connected with the market, but the third party is representing them.
Exactly. इसमें हम सबसे बेहतरीन एग्जांपल किसकी दे सकते हैं? मोटर डीलर्स, or you can even say the distributors of movies. Okay, so they
Yeah.
are not actually the ones who make the movies, but they are the distributors, right, to different cinemas where the movie will be watched by many clients, many customers. So that is known as a factor. Broker. Who's a broker?
Broker is the one who takes commission, who's like selling my property and taking commission from me and from the other person as well.
Exactly. He's a broker. He can be insurance broker. He can be a property broker. He can be a shares broker. Anyone who is making or selling a particular commodity or a service which belongs to somebody else. Next, auctioneer.
Auctioneer, something related to auction, like we're auctioning our property or auctioning our maybe a painting, our
Exactly.
belonging. We
Exactly. So the person who is conducting the auction is known as the auctioneer,
auction.
and therefore he is playing the role of an agent because the products or the services he is auctioning is not does not belong to him. He is not the owner. Owner is somebody else, and he is just connecting. He's acting the role of a connector between the customer and the seller, between the purchaser and the seller. Okay. Next, commercial agents.
Commercial agent, like if I want my property to be rented out, so I'll just go to the commercial agent. I'll ask them
Yeah, you
that
can just
I
call
need.
them freelance agents who work. जिसको कुछ भी दे दो उसको कुछ भी बिकवाना होता है बस. फॉर्मेशन ऑफ एजेंसी. एजेंसी यानी कि आप अपनी एजेंसी रोल को, उस काम को एक एज अ प्रॉपर बिजनेस या प्रॉपर ऑर्गेनाइजेशन लेकर चलना चाह रहे हो कि यू आर एन ऑर्गेनाइजेशन ऑफ एजेंट्स एंड दिस इज व्हाट यू डू. यू प्रोवाइड सर्विसेज of getting your products and services sold in the market to the right person, connecting the right sellers and right purchasers with you. So फॉर्मेशन ऑफ एजेंसी और ये जो ताल्लुक है, ये पहले तो एक ये ताल्लुक हो गया कि मैं एजेंट हूँ और मैं इसको एज अ प्रॉपर कारोबार करना चाहती हूँ, ठीक है, एक तो ये हो गया। दूसरा, किंजा आप जो हो प्रिंसिपल हो, आप अपना मोबाइल बिकवाना चाह रही हो, आप अपनी प्रॉपर्टी बिकवाना चाह रही हो, तो फर्स्ट यू हैव टू agree on the fact that okay, Miss Isha, can you be my agent, can you please help me
Yeah.
sell this mobile, can you please help me sell this car, I have this property, can you please help me do that. So you are coming to me and we both are agreeing on mutual basis that okay, I am ready to play the role of agent for you and you are ready to play the role and you are accepting me as your agent. Okay.
Yeah.
So that could come as an express agreement, यानी in words आपने बोला है या in words आपने लिख कर दिया है. It could be implied agreement. It's but obvious
It's
कि
obvious.
अगर तुम मेरी बहन हो तो मैं तुम्हारे किसी भी बिजनेस को प्रमोट करूंगी ना, मैं तुम्हारे किसी भी काम को से मैं जरूर अपने व्हाट्सएप स्टेटस पे लगाऊंगी ना. श्योर आई विल बी बिकम योर agent without even you telling me, or you know, without we both of us formally agreeing to it, because we are sisters, it's understood. You will be promoting me, I will be promoting you, so that's how it works. Implied agreement due to relationship or conduct of the parties. Make sense? यहाँ तक clear है बात?
Clear, ma'am.
ओके, आगे बढ़ते हैं. रैटिफिकेशन ऑफ एन एजेंट्स एक्ट, रेट्रोस्पेक्टिव एग्रीमेंट, व्हाट डज दिस मीन? प्लीज रीड.
A principal may subsequently ratify an act of an agent retrospectively.
What does this mean?
If I don't want that agent to help me out anymore, I don't want to listen to him, I just tell him straight away. The principal can tell the agent that no, I'm not interested anymore, rectify. It's not that I'm bound to follow whatever he says.
Yeah, but ratify does not mean that. Ratify means to confirm. If you just check out the dictionary, just let us check it out on Google. What does ratify means? Approve, act, or sanction, or confirm. Okay, did you find?
Yes.
It means to approve, to confirm, to say yes. Okay. So what is
Yeah, I
happening?
think sign or give formal consent to a
Yes.
treaty, contract, or agreement, making it officially valid.
Making it officially valid. Now, for example, let's take a domestic example in this. किंजा, आपकी मम्मा मेरे पास आती हैं आपका रिश्ता लेके, ठीक है, और बोलती है कि ईशा आपके भाई से मेरी बेटी का ना रिश्ता करा दो. Now, what am I supposed to think? I am supposed to think that, okay, I think my brother and Kinza have met somewhere, they know each other, maybe they like each other, and therefore she has taken the courage to send her mom. So, what I'm thinking that Kinza की रजामंदी है तो ही तो उसकी मम्मा आई है मेरे पास. Kinza knows, Kinza agrees, and therefore her mama has come to me. What I do, so over here, what is happening? Your mama is the agent, is acting as an agent for you on behalf of you. Okay. And I am acting as an agent on behalf of my brother because she has come to me, right? So we both are acting as agents for the respective parties. But now what is happening? I might think that, oh wow, Kinza is such a nice girl. She's my student also. Yeah, she's good for my brother, this, that. And I might say yes to your mother. Okay. Now what will your mother think? Your mother will think that, okay, I am agent of my brother. So that means मेरे brother की भी कुछ होगी ना, मतलब my brother knows about it and he agrees to it, and that's why I said yes so confidently. हालांकि मेरे भाई को कुछ नहीं पता. एंड इट इज पॉसिबल कि आपको भी कुछ नहीं पता, ये बस दोनों एजेंट्स के दरमियान बात हो गई. ओके, Now, who is going to ratify this contract between verbal contract between us? You, because you're the principal in that case, in the opposite
Yeah.
party, and my brother who is in this case on this side. So unless you both ratify the act which we have done, the agents have done, this is not going to proceed.
Okay.
But once both of you give the agreement, you give it, you ratify that yes, मैंने ही अपनी मम्मा को भेजा था, and I asked my brother, and my brother says कि क्या आपने हाँ बोल दी? अच्छा चलो आपने बोल दी तो चलो कुछ सोच समझ के ही बोल दी होगी, आप
So
मेरी
that
बड़ी
means
बहन
the
हो.
agent does not have that authority. They can just talk about it, but the signing
Yeah,
procedures and everything only the principal would
exactly.
be doing.
It means there is no formal authority given to the agent, but the agent acts as per the situation.
Okay.
And then the principal comes into knowledge later. And when the
Okay.
principals get this knowledge, then they can do either two things. They can either ratify or they can say, no, sorry, we don't agree.
Okay.
You did it yourself. We are not responsible. So there are two ways that the contract can be treated, right?
Okay.
Formation of agency agreement without consent. अब कंसेंट है नहीं प्रिंसिपल का, लेकिन एजेंसी रिलेशनशिप बन गई है. कैसे भाई? This happens by estoppel, when the principal holds out a person to be their agent, and when there is an agent of necessity. So there are two ways by which the agency agreement can happen without consent. That means principal की रजामंदी ना भी हो तो ये दो situations हैं कि जहाँ पे agent can act on behalf of the principal. The first situation is by estoppel. By estoppel means what? It means, for example, the student comes in this institute, and the student is talking to the teacher, and the teacher tells the student, like, I told you that stay connected with the team, let the team know when you are ready for the exam. Okay, so you are saying, you are looking at the situation that okay, मैम निशा ने तो बोल दिया है मैं मिस रिमशा से कांटेक्ट कर लूँ या मैं मिस बुशरा से कांटेक्ट कर लूँ. So I am holding out, or I am treating that other person as my agent or as the agent of ISA. So you can approach them. You as a customer, you as a student are observing that okay, I'm telling everything to Rimsha, or I'm giving instructions to Bushra, or I'm giving instructions to them. So you have assumed this, that yes, they are the people of the team, or they are the team, they are working and they are agents. So I can approach them. So by my conduct, by my action, you're deducing or concluding to this point. So there is no way, even if I had not formally given the responsibility to any of these people whom you saw, that with whom I am talking, then also they can perform or act as an agent because you saw them and you saw me doing something with them. So therefore
Okay.
you are reducing to that.
Okay.
Then, when the principal holds a, that's by estoppel. That's agency by estoppel. Then, agency by necessity. What does that mean?
By necessity, at times we cannot move without the agent. Like sometimes, if you talk about UK, if I am giving a house to someone, there should be an agent in between. In Pakistan, it's okay. If there is no agent, that's fine. But in UK, you have to have an agent so that they can sign up the contract, they can look into the matters,
No,
the agent gets the rent.
no.
So it's a necessity.
Agents by of necessity means, for example, I order a Kareem or a Uber. Okay, I sat on it and I want to go somewhere. Okay, maybe I want to go to a mall, and the Uber driver or the Kareem driver, he drops me. He drops me there, and I forget my bag or my wallet in his car. And I get off the car and I go to the mall and I don't realize that I've forgotten something. So when the driver finds out that some property of mine has forgotten or is left behind, what should he do?
You should go to the Kareem owners and the main,
First of all, he should keep that belonging safely,
yeah,
and then he should try and get it back to me.
yeah,
Now, there are possible ways. Either he comes back to the mall, waits there for me to come out of the mall to realize that I forgot. Okay, or maybe he submits it through the Kareem owner, the agent who is responsible for the lost belongings. So now this driver is acting as agent by necessity for me.
Okay. Okay.
Okay, he is keeping my belongings safely with him. He is dropping
Okay.
it to the appropriate person, or he is trying to find the owner and trying to return it to him. So he
Okay.
is acting as agent by
So
necessity.
without any option, he's just doing his job. He doesn't have any option now.
It's not option. He can even misuse it. He can sell off that belonging. If I left my
Yeah,
phone,
but
he can
actually,
sell
he's
it off.
not actually, he didn't want it to, he was not willing to be an agent. But now the circumstances, so now he has to
He is
be an
just
agent.
performing an act of humanity, and that makes him an agent by necessity. We
Okay.
can use another example. For example, we just get into an earthquake right now, and there are
Yeah.
so many children in the school. Maybe there is one small nursery child coming out or crying for help, and I'm just outside the building and watching everything shake and fall down. And I see that one child who is from our nursery class standard, and she is crying, standing there. Nobody is there to help her out. So I just hold her hand and I take the responsibility of her. So out of humanity, I'm doing that act, but in the eyes of law, I'm becoming an agent by necessity, and I'm agent of whom? Of the parents of that child.
That's right.
Okay. Next, authority of the agent. Authority can be express authority, it can be implied authority, it can be ostensible authority. Express authority, I have verbally or in writing expressed it that Miss Rimsha is responsible for the mocks. I am giving her the authority to give access to students whose mocks needs to be conducted, whose test needs to be conducted. I am giving her the authority. Or I'm implying, I'm not saying it with my words, but it's
But it is
obvious.
obvious.
It's obvious that there is no other person who is responsible for this. So it is
Yeah.
obvious that she is only here, so she is responsible for this. Ostensible authority. Now, what does ostensible mean? All right, please read.
An agent, apparent ostensible authority. An agent's apparent or ostensible authority may be greater than their express or implied authority. This occurs where a principal holds it out to be so to a third party who relied on the representation and altered their position as a result. It may be more extensive than what is usual or
All right,
dissensual.
all right. Now here, the word is being used apparent. Apparent means clear, very clear. Ostensible also means the same. And it is saying that this authority is greater than the express and implied authority.
Yeah,
So let's take an
like
example over here. And what is happening in this? The principal, that means if I am the head of ISA, I as a principal, I am holding out to the third party. You are the student, you are the customer. I am holding out to you that, Kinza, our institute is affiliated by ACCA. Do you know, Kinza, that हमारे इंस्टीट्यूट के बड़े अच्छे ताल्लुकात हैं आगा खान बोर्ड से? डू यू नो, किंजा, दैट हमारे इंस्टीट्यूट के बड़े अच्छे ताल्लुकात हैं कासमनी शाह से? All
okay.
right. So indirectly or directly, I am very apparently announcing or saying that so and so personality is associated with us, or we are associated with such a reputable institute or such a reputable person. So this
Mhm.
creates an image in your mind. Oh, okay, they are connected with them. Okay. So it is creating a brand image in your mind. And you are also thinking that okay, अगर ACCA ने approve किया है ISA को, हिसार को, so that means that they have something in them, or they are abiding by the rules of ACCA, and ACCA तो अपनी हर चीज standardized देता है. So so your trust is developing more on us. and you might be taking some decisions based upon this statement of mine.
Okay.
So that is ostensible and apparent authority. And what is ACCA doing? I'm showing them as our agent, right? Or I'm showing myself as their agent. Okay, so that's what's happening. Okay, okay. So all of this has been discussed through the example. We can go through it. Revocation of authority. Revocation means what? You trusted someone. You trusted someone because you thought, as a customer, you thought that that particular Mr. X is our agent, and you took a decision or something like that. And when I got to know about it, because I'm the principal, I'm the owner, I will say, no, sorry, he's not our agent. How dare he do that?
Okay.
And you did a wrong thing. Why did you assume yourself? He's not our agent. Sorry. So what am I doing? I'm revoking the authority.
Okay.
That's revocation of authority. Okay. Then termination of agency. If there is death, insanity, or insolvency, the agency relationship might terminate. Like, for example, as I said, that two brothers, they are running the same organization and they are partners, they are acting as agent for each other. But if one of them meets with an accident and maybe he goes insane or he goes into coma, so can that agency relationship continue? So it's terminated, right? So principal or agent dies, principal or agent becomes insane, or any one of them becomes bankrupt. So in all these conditions, what will happen? The agency relationship will terminate,
Terminate.
right, Kinza?
Yes, ma'am.
Okay. Now, relations between agents and third parties. What does this mean? Agents and third parties. Agents and third parties means the customer and the agent. How there could be a relationship between both? An
They
agent,
have a relationship because they both are agreeing together.
an agent usually has no liability for contract entered into as an agent. अगर मैं एजेंट हूँ और मैंने दो पार्टीज को मिलाना है, ए और बी को, तो कॉन्ट्रैक्ट इज बिटवीन ए एंड बी.
A and B, not in
I am
between.
not
Yes.
liable for anything apart from
Yes,
just getting them engaged.
exactly. If B is not agreeing to anything, it's not your fault. It's their own fault, their
It's
own
their own
concern.
matter. It's not my
Yeah,
matter is just to connect them. That's it.
that's
And when
right.
I connect them, for connecting, I take a commission. That's all. That's all I do. After the connection, during the contract, if any kind of conflict arise, agent has nothing to do with it. They have need to solve the matter themselves. Okay. A third party to contract entered into with an agent acting outside their ostensible authority can sue for the breach of warranty of authority. Now, the third party, the client or the customer, like you're the student, and what you can do, you trusted an agent, you trusted someone to be an agent of ISA, and you acted according to the agent's guidance. Okay. Later on, you found out that this person does not have the authority to act as an agent. So what you can do, you can sue this person to pretend to be the agent when he was not supposed to be an agent. So you can sue them for breach of warranty of authority.
Got it.
Liability of the agent for contracts formed. If two parties are entering into contract, what is the liability of the agent? Please read, Kinza, first.
When they intend to undertake personal liability, for example, where they sign a contract as party to it without signifying that they are agent.
Okay. अब वो किस सूरत में लाइबल होंगे एजेंट? जब वो खुद उसको साइन कर रहे होंगे कॉन्ट्रैक्ट को,
Exactly.
without signifying that they cannot sign because they are just an agent.
Yeah,
Then they would be responsible. They would be liable because they signed.
of
Next.
course. Where it is usual business practice or trade custom for an agent to be liable and entitled.
Right. जब
Okay,
एक
when they
custom
are
है,
liable, yeah, it's
एक
a
practice
norm.
है.
Exactly.
जैसे कि मैंने एग्जांपल दी, आपकी मम्मा आ रही है रिश्ता लेके, तो इट्स ऑब्वियस कि अगर आपकी मम्मा आ रही है तो वो एजेंट है, वो आपकी एजेंट है, और मतलब मेरा उन पे ट्रस्ट करना बनता है। मेरा ये अज्यूम करना कि किंजा ने भेजा है, किंजा को मालूम है इस बात का, ये मेरा बनता है। क्योंकि
True.
नॉर्म ऐसा है, कस्टम ऐसा है कि हाँ, यहाँ पे फैमिलीज एक दूसरे के घर प्रपोजल लेके जाते हैं। इट्स नॉट द पर्सन, द फैमिलीज टेक द प्रपोजल्स, राइट? So it's a norm. So then she is liable if she says yes, or she makes a statement and then she backs off. She is liable definitely. Okay, next, where the agent is acting on their behalf.
On their own behalf, even though they purpose to act for a principal. Okay, actually, they're doing their own business and they're actually the ones who have the authority. So, yes, then, like you were talking about A and B,
Right.
if both of them, so obviously they are agent on their own behalf.
So that's fine. यहाँ तक clear है. Breach of warranty of authority. I hope this is also clear. When the agent does not have the authority to enter into a contract, but he does, he does perform out of beyond his authority.
Yeah.
So the third party can sue him for breach of warranty of authority. Okay. So here we have completed this chapter as well, the agency law. I hope it's clear.
Yes, ma'am.
That's great. Any questions? Alhamdulillah, we are done with this as well. Ali missed today's class, or is he there? Listening quietly. Okay. So when are you planning to give the test, Kinza?
Ma'am, maybe tomorrow.
Ali, आपने दे दिया? Ali, did you appear for your test yesterday? Okay, I think there's some mic problem. Cannot hear me. ओके जी, चले जी, इंशाल्लाह फिर कल मुलाकात होती है। आज यहीं तक। हैव अ नाइस डे, टेक केयर, अल्लाह हाफिज।
You too, ma'am. Allah Hafiz. Thank you.